I'd like to introduce Attorney Joseph Bernard. He practices out of Springfield, where he has essentially become one of the preeminent criminal defense attorneys practicing not only criminal defense OUI, but again, advancing scientific progress of OUI defense. He has dedicated his practice towards understanding, incorporating, and litigating the science of OUI, and has become accredited in a number of courses involving training for alcohol technology, as well as gas chromatography. He was the lead attorney in the statewide litigation in Commonwealth Ananias, which challenged the reliability of the Draeger Alcotest 9510 breath test results, and his representation contributed to the unveiling of discovery violations made by the Massachusetts Office of Alcohol Testing, ultimately leading to a state investigation into the laboratory. Mr. Bernard is also the co-author of volume 50 in the statewide mass practice series, Drunk Driving Defense, and he maintains schedules of lectures educating lawyers such as ourselves as to how to litigate post-trial Rule 30 motions. We are, on behalf of MACTL, we're very, very pleased and grateful to have him here with us today, and I'll turn it over to Attorney Bernard. Thank you.
Thank you so much. And it seems as if Ananias began, we were just chatting, Mr. Ananias, a 2012 case. So it's almost been 10 years since this has been percolating along, but we're here. And what I wanted to do is kind of give you an overview of these motions to vacate. But before I do that, there are some, I think, issues that I'd really like to talk to you guys about. Let's see. And Stephen, why don't you help me out here? Because I am, how do we advance this? My man, here, come here. Just having some technological difficulties here. There we go. Okay, thank you, Stephen. Stephen, so I don't know if you remember, but she's always in the background. But boy, oh boy, there couldn't be any Ananias without my very dear friend Ann Goldbach. And one of the jewels of this, experience was getting to know her and call her a dear friend. And as many of you might know, she's retired, and I stay in constant contact with Ann. But the current state of affairs, I think it's really important that we talk a little bit about what's going on with breath tests now. I'm not going to spend a lot of time, but it's important. I think most of you across the state are probably experiencing what's going on here in Western Mass, and that is that breath tests are not currently being offered. There's a kind of a voluntary, what I'll call a voluntary moratorium that is being put on the use of breath tests. So any criminal defense lawyer who's handling these cases really needs to be sensitive. I got a phone call today from somebody who was filling out a tender of plea form, and he was ready to submit it. And I said, whoa, stop. And I sent him the information that particular DA had sent out a memorandum to all line DAs, can't submit a breath test. And that was the cornerstone of the case. And I'm not suggesting that particular DA was doing anything surreptitious or anything disingenuous. I'm just suggesting that we as lawyers need to realize that they're not using them in a vast majority of the counties. And it's for the reasons that I have set up right here. We'll talk a little bit about them. Uncertified breath test operators. There is a number, and what that number is, we still don't know. With 12, 15, 20, I'm not sure. But it goes back about 6 or 7 months ago that the Office of Alcohol Testing we're producing results from breath test machines from uncertified breath test operators. And as you know, the statute mandates, one of the foundational underpinnings is that a breath test has to be produced by a certified breath test operator. So be aware that is out there. The cleaning, there's a whole cleaning and mouthpiece protocol. During the COVID crisis. I don't want to even put in the past tense, but while we were under that severe state of lockdown, the Office of Alcohol Testing developed a cleaning protocol, and they also, during this period, introduced new mouthpieces and a new mouthpiece protocol. My complaint, if you will, was clearly I think they were trying to do the right thing, but we as lawyers and judges and we all should have known about it, right? And we'll talk about one of the advancements that I really tried to push, and there's the e-portal discovery and the transparency and the cleaning and mouthpiece protocols had been changed 4, 5, 6 months, and they hadn't been published on the e-portal. They are there now. There's also some training that we'll talk a little bit about. And of course, in 2020, the breath test machines were producing breath test results with missing fields, specifically the pains and penalties of perjury. So I'll just quickly go over this. I sent this letter to Chief Justice Carey the beginning of May. It's available for you to see, but it outlines some of my concerns that I had hoped were remedied in Ananias, the transparency, the dysfunction. I don't know substantively the impact, but I do know that we as lawyers, and I say that lawyers being defense lawyers and prosecutors and judges, had a right to know of these particular changes, and we had a right to know. The most bizarre thing to me is that there are a group of individuals, citizens, who 5 or 6 months ago maybe pled guilty. I don't know, maybe we didn't have any trials, but certainly there were pleas, and potentially they could have been illegal breath tests. We don't know, because the Office of Alcohol Testing has not produced the names yet. And I'm hoping today or tomorrow we're going to get a response. But I sent this out to Justice Carey. She responded, and right now we're still in a little bit of a holding pattern. But the DAs, to their credit, actually have done the right thing and put a moratorium on it. This is a motion that I filed. It's still pending in Ananias. I'm not sure Judge Brennan wants to have anything to do with it, but this has to do with the missing fields, that the machine was producing results without the pains and penalties of perjury field. There's the 9510 has as particular affirmative responses that the operator has to actually fill in. And again, the statute mandates that the operator has to do this under the pains and penalties of perjury. And as you might have read, there were results going out to the Registry of Motor Vehicles, and quite frankly, the machine producing the results without this particular field being affirmatively answered. I think the operative orders, I think what is going on is that there is a patch or Draeger in Texas is working on some sort of a fix on this, but it remains a problem, and we had a right to know about that. So I show this to you as well. Be aware that the agent of the government, the Office of Alcohol Testing, we'll talk a little bit more about that. The DAs, this is a discovery request that the DA sent out to their own agent, and this is one of the big reasons why we're not using breath tests today across the state. If you have a breath test case, I would highly recommend that you at least ask for this, ask for the discovery that the DAs have requested of their own agent, the Office of Alcohol Testing. This is the cleaning protocol, and I'm not going to get into it, and the mouthpiece protocol. If you have a breath test machine, case, take a look at the video, analyze the two appropriate protocols, and we could go on and on with that. But I just kind of wanted to highlight, what is currently going on right now. And, I'm a little disappointed, but I hope all of this will be remedied. And I really have to credit, the district attorneys across the state. They've all gathered together, and I think they're speaking in a collective voice, that they're demanding some answers from the Office of Alcohol Testing. This is a scientific calibration lab for the people. We pay for this scientific lab to produce results. And all I've ever said from the very beginning of this litigation is just fight fair. Just give us the information and be transparent, open, and honest about it, and just stop hiding. This, believe it or not, this protocol was not published, and they were changing mouthpieces, and the mouthpiece protocol had changed, and the cleaning protocol had changed, and we didn't know about it. So, all right, that's essentially where we are right now. And if anyone has any questions regarding that, by all means, call me. But I wanted to get back into the motions to vacate, and it is important. I'm not going to bore you with the details, but the history of Ananias is somewhat important, because as you present these motions to vacate, one of the themes that I'm going to talk a little bit about is that I hear lawyers, and I get a lot of questions about this. Judges sometimes call me. It is not strictly a discovery violation. You've got to really recognize that this is about the substance of the scientific reliability of a measuring device. When we first began the Dahlberg-Lanigan challenge, there were a variety of different issues that we raised in front of Judge Brennan. And to Judge Brennan's credit, he really did an extremely robust examination of the 9510. The source code was the main probably focus of a lot of attention, and that's what they focused on in Camlin. As lead counsel, I felt that there should be other areas to be examined. And what I argued, and Judge Brennan agreed, that we began to identify some of the other underlying principles, just a breath test, the science of breath testing in general, the blood-breath ratio, interfering substances, and other issues were all challenged during the Dahlberg-Lanigan 2-week hearing in Concord. Now, I will tell you, the source code, the blood-breath ratio, the interfering substances were all found to be, for the purposes of the Dahlberg-Lanigan hearing, sound principles, and for the scientific underpinning of the machine, it was deemed to be valid. But it was with the maintenance and the protocols of the Office of Alcohol Testing that we were able to show the scientific unreliability of the results. And that's what you need to recognize, that the methodology, the protocols, the missing worksheets, all of this bears directly on the scientific reliability of the results. It's not a discovery penalty or violation. You can't just think about it like that.
2 questions.
There's 2 questions, and evidently they're fairly. So let's see what they are here. All right. So yeah, and Ed Ryan, wonderful question, and I think it's topical that I'm just going to interrupt very quickly here. And the question is, so why are the police still offering breath tests since they cannot be used in courts? And why is the Registry of Motor Vehicles still suspending licenses for refusals and failures? Well, I mean, we could say that about, that's a great question. It was a great question during the period of Ananias litigation. And I'll answer it very, very briefly, that the manner, and we all know that the standard of proof and the burden of proof in the Registry of Motor Vehicles Administration is very, very different. I was somewhat successful at the beginning raising that particular issue, but right now I would say that the Registry of Motor Vehicles is satisfied with what I would suggest is a superficial response from the Office of Alcohol Testing. I don't want to get too much in the weeds, but I will say that the Office of Alcohol Testing did respond to my motion regarding the missing fields by some vague affidavits from an engineer, and they were also sent to the Registry of Motor Vehicles. And right now the registry is satisfied, and police and law enforcement are continuing to offer these tests in the hopes that eventually the Office of Alcohol Testing, gets their act together. keep in mind that this is a voluntary moratorium that some of these DAs have put upon the use of breath testing. And the hope, and as I've been involved in some of these meetings, the hope is that the Office of Alcohol Testing will identify and show to the DA satisfaction that these tests are now being conducted in a manner that's responsible. One of the big issues, and we'll talk about this, is the validation of their changes and the validation of some of these remedies that they have to put into place. So I don't want to spend too much time. Obviously, Ed Ryan asks wonderful questions, as he's one of the better lawyers in Massachusetts. But I hope that, and I'll speak to it in more detail afterwards, Ed, if you want to. But I want to get back to this, and Judge Brennan really took a very hard look. And again, the science is important, and we gotta realize that when we began to look at Ananias in this, I don't know, it was 3 or 4 years of discovery. Keep in mind what he found, right? The methodology and maintenance of the machines, okay? That is what produced the unscientific results. So remember, we have Ananias 1 and Ananias 2. You're going to be arguing some of these motions to vacate, and your people and prosecutors are going to get mixed up, and they're going to try, to differentiate between Ananias 1 and Ananias 2. And you've got to recognize that the agreement that we reached and the order really makes them one and the same. And that the point I'm trying to make here to you is that the methodology and maintenance from that 2014 to the present, okay, and that date you're looking at, that 2014 date, was the end date for the first Ananias decision. Do not let your prosecutors argue that, well, it's after 2014, somehow this is a different standard. It's not. The reason it's not, and we'll talk a little bit more, is because Ananias 2 really dealt with the failed worksheets. And it was a decision, as I say here, that was based on the Ananias 1, as Brennan said, was based on false information because you failed to give the lawyers the worksheets. How could I make a decision on the reliability of all of this when you didn't give them the appropriate information? You hit it. And what I want you to know is take a look at all these decisions, and they're all available to you. But you've got to realize that that first decision from 2011 to 2014, that language is important. Presumptively excluded. Why? Because you didn't properly maintain the machines. And that is what the judge said, that you cannot convince me that this machine was calibrated in a proper, scientific, reliable way. You can't, because you didn't have the proper protocol to calibrate the machines. And with that, now that you didn't permit the defense to explore that, I have no idea whether or not these protocols were being appropriately used all the way now to 2019. We'll talk a little bit more about that. I'm having some more difficulty here, Steve. Yeah. So why does that happen? Where? Thing here. That's all. Oh, that was easy. All right. So again, Ananias 1 was that 2-week hearing, and I just kind of talked a little bit about that. I won't talk. What happened after that was, this is when we discovered, my very dear friend, and I don't want to just say it's me. Without Tom Workman, we would be, he was just amazing. And it was Tom who relentlessly called me every single day. And I recognized that these worksheets were a huge source of controversy. And I remember as if it was yesterday, going in front of Brennan, and in looking at me, shaking his head, he said, "Mr. Bernard, this is a motion to reconsider, a motion to reconsider." He says, "What are you here for?" And I said, "Judge, I still don't have the protocols." And it was that time that the Office of Alcohol Testing says, well, Judge, we don't have protocols. We didn't have protocols. We have worksheets. And I said, then I want the worksheets. And during that back and forth is when he ordered the Commonwealth to produce any and all worksheets that represented this protocol. And it was Tom who discovered through analyzing, because recognized that every single time the Office of Alcohol Testing calibrates one of these machines, they have to electronically register. So he was able to see all the points where the machines were being calibrated, and he took all the worksheets that were provided and he linked it up, and we were missing, and we'll talk a little bit. I think we were missing like 445 or maybe 450, and they were able to produce the bulk of them afterwards, but that's what we're missing. And every single one of those 432 worksheets that they did not give us failed. Those were failed calibrations. So it was after Ananias 1, when Brennan issued the decision, that we discovered of these failed worksheets, and EOPS went immediately in after a lot of different news media outlets published the story, and the Office of Alcohol Testing was shut down for a period. EOPS, there were 3 lawyers who went in, state police, and there was an enormous investigation. And to the governor's credit, it was very thorough, I look at some of the interviews that Doug Levine and his colleagues did. They were very, very thorough. And the difference between Dukin and the Ananias case was the fact you guys are going to actually have those transcripts of the interviews. And unfortunately with Dukin, we don't have those. We have synopsises of that. So if ever you need it, they are available. So there we are, Ananias 2. I was involved, and they brought in Vince DeMoore, excellent lawyer from the Dukin Farak, and he came in with Casey Sylvia and began to represent the government. And after tens and thousands of documents that were being showered upon me that should have been given, in Ananias 1, we were able to sort through it, and myself, Casey Sylvia, the team, and Vince DeMoore, I approached them with a suggestion that we could have an agreement. So we spent months putting together this particular agreement, which is a contract, by the way, and it was adopted by the court. Now the agreement, and then Ananias 3 is the last part of the trilogy here, because it's Ananias 3 that gives you that April 18th, 2019 date. We had a 2-day hearing to determine when the breath test could be allowed in, when the judge determined that the lab was actually at a point where he felt comfortable permitting breath tests to be allowed. So again, I would encourage everybody who is arguing these motions to vacate, read the investigation. Any of us who pay taxes here in Massachusetts, it's a little disheartening when you read it, but it really casts a wonderful, I would say, light on what was going on. The only arm, for those of you who do a lot of other cases, it was the only arm of the forensic science that did not have any type of third party and investigation. And without that, it really did not have the significant validation that all the other crime labs had. So without that accreditation from that third party, you didn't have it. And that was one of my big contentions, is the fact that it's the only arm of the scientific forensic lab that doesn't have accreditation, and now it does. So again, you can read it. You can see some of the language that long-standing and insular institution culture was reflectively guarded. And it really was. Any of us who practiced, pre-Ananias realized, it was always a very difficult situation trying to get information out of the Office of Alcohol Testing. So the joint agreement I talked a little bit about. Please be aware. We'll talk about one of the grounds but it is a contract. And the reason it is, I insisted, there's wet signatures. Every single district attorney from the Berkshires to Boston to Cape and the Islands signed off on it. And it's a promise. And I did that because I really felt strongly about the fact that, you know, this was not an appeals court case. This wasn't an SJC case. And what I didn't want to have happen was, as time rolls on, you know, memories fade, people start arguing. And the fact of the matter is, though, this was all agreed to by every single DA across the Commonwealth. And as I said here, that, yeah, ANAB with accreditation, and that did happen. As we sit here today and talk, they are accredited. So this was some of the language, and you can see in the joint agreement what we have. It's important when you argue these motions to vacate to recognize, and we'll talk a little bit about the importance of the language here, right? So intentionally withheld, you know, I put that language in. Now, can you imagine that you're arguing in front of a judge and you have newly discovered evidence, and, you know, as a general rule, you know, we're not, you know, lawyers are not surreptitious and liars, but here we have a situation that I tried to couch the language to provide you guys, you know, as we marched into the future with the ammunition to go and not have a lot of back and forth arguments. Intentionally withheld exculpatory materials, that is in the order, that is in the agreement. So it's there to be used appropriately when you're arguing these motions, so you do not have an awful lot of pushback, right? You can't. And again, these are with breath test machines. We'll talk about that. The order you can see here, and I want to emphasize as this, because you're going to have some prosecutors, I think, giving you pushback again on this issue of it's a discovery violation. It's not a discovery violation. It went at the heart of your case. When you're representing clients who have a breath test case and you're looking to vacate, a lot of them are pleas, some are trials. But when you're doing that, keep in mind, you know, this is a big deal. This is probably one of the most important pieces of evidence that the government has, that we as litigators know is kind of the cornerstone of a lot of these drunk driving cases. So the language in the order you can see here that I've quoted is part of the Ananias 2. It's part of the failed worksheets. And again, I say to you, it's not the discovery violation. What Brennan is saying in the order is it goes at the heart of the scientific reliability, and I can't tell. And he says, how do I know? It certainly was important. It was not negligible, right? And how can I determine this retrospectively, right? Hundreds of thousands of dollars were spent. Experts from around the world were flown in. And here we are now, and you did not provide this very important information, the worksheets. So that's what happened, right? We had that Ananias 1 case, and that brought us to 2014. We discovered the failed worksheets, and then the court expanded the order. Again, I know I'm repeating myself, but I've now that these motions to vacate are out there, judges, and I hear lawyers argue, and I hear prosecutors give pushback on this, please, you've got to recognize that it is not some sort of a discovery, or it's not. So keep in mind, it's all about newly discovered evidence that you should have had that you didn't have. There are some exceptions, and then keep in mind that was part of what Vince Demore and Casey insisted on, and this was part of the agreement. So you can see that some of the more serious cases, fifth offense, homicide cases involving personal injury. Now, they are not, keep in mind that the carve out does not permit the Commonwealth to just randomly throw these cases in. They are still under the presumption of exclusion, but with these cases, they have a right to present the breath test. Keep in mind, they don't have a right to present it in any of the other cases, and it's a promise not to be used at trial. and you'll see that in the order. That's the big difference, right? So with more serious cases, they can present and overcome the presumption, but the fact of the matter is, on all other cases, they can't use it, and you need to know that. So you can utilize, if you have a serious case, keep in mind the presumption is protecting you. Again, I talk a little bit about this. It's really important that the parties agree to be bound by the decision of this court. I was always concerned that yes, Justice Bosford and yes, Justice Dolly and Kerry, consolidated this class action, but I really and truly was a little concerned about, as we came out of this, what was a district court judge going to do in 4 or 5 years? So I did include something in there, and we'll talk a little bit about judicial estoppel. And keep in mind, that's the definition. So it precludes the party from taking a position in a case that is contrary, right? So as we move forward, the DAs have all signed off on this, and maybe the DA, who signed off on it is not the DA, 2 or 3 years from now, but they're bound to the agreement. So what I really wanted to do was try to create, to the best of my ability here, something that could give you the teeth as we move forward on these cases, and not just some district court decision that is being ignored. So again, that's the judicial estoppel. It's in the agreement and it's in Judge Brennan's order. The agreement that was signed off on was adopted by Judge Brennan and incorporated in his order. So it's there. It's not only a potential contractual ground, but it's also in the order itself. So I talked a little bit more about this. Again, it's I don't want to keep repeating it, and time's ticking, but I emphasize the 432 worksheets go to the scientific reliability. You can see, and that's Ananias 3. Ananias 3 was all about when could they start using them. There were experts called, I called Janina Arvizu, and I think they called, Director Sullivan, she testified, and we talked all about, we cross-examined pretty extensively on issues regarding protocol, issues regarding validation studies and things of that nature. Keeping in mind, everybody, that when the Office of Alcohol Testing actually produces a protocol, whether it's cleaning the machine, whether it's mouthpiece, any change in the scientific lab needs to be validated, right? And that the accreditation body, ANAB, will be looking at closely. So that's in essence where we are with kind of the history of Ananias. I emphasize, there are 3 decisions all available, but some of the things that really came out of Ananias were right here. A big part of it, by the way, was that e-portal, and it sometimes becomes a little bit difficult to use, but it's a huge step forward for us as lawyers, prosecutors, and defense lawyers to actually obtain information for you to view and for your experts. That's, again, the method validation. I've talked a little bit about that. So when you bring these motions to vacate, the majority of the motions to vacate, I would suggest to you, will be pleas, right? Some will be trials. I've had trials, but the majority of them will all be pleas. Hence the reason why I couch a lot of these Rule 30 motions and motions to vacate. I saw some motions to withdraw, and believe it or not, people see it, and judges in the district court are moving awful fast, and they're calling the case, and they really think it's a motion to withdraw the appearance. So anyway, This is some very, very basic concepts, right? And we'll talk more about the manner of what to argue with these motions. But one of the the pieces that, you know, take a look at Rule 30, and it gives a judge a great deal of discretion, and it puts a great deal of discretion in the judge's hands when justice needs to be remedied. So there are some cases, and we'll talk about them. There are essentially going to be, I would suggest to you, with your motions to vacate, three basic reasons, three basic premises that you should be focusing on. But I just had such a wonderful conversation with Laura Mannion. And keep in mind, if there are other reasons, you have got to put them into motion, or you're going to waive. But for the most part, a motion to vacate under Ananias will be a due process, a newly discovered evidence, or you could even have a contract claim. We'll talk more about it, but read that Scott case. The Scott case is your Dukin case that adopts the Ferrara standards. And it's important that you look at that case. If you read no other case, and I wouldn't suggest doing that, that's going to be your key case. Commonwealth versus Scott is a wonderful case. There are obviously some differences, but it's a great case to familiarize yourself with how to argue these motions and recognizing what you have to cull out of some of these cases. So it might seem obvious to you, but what is the newly discovered evidence, right? The newly discovered evidence is the unreliability of the breath tests. And it's not, don't let a prosecutor, drill down and say, well, your case wasn't part of the Ananias group. Your case, no, let's stop. This is a statewide decision. This is a statewide exclusion. And I should have known, I'm the lawyer representing Mr. Smith or Miss Jones. I should have known about all the problems that were going out at the Office of Alcohol Testing. And because I didn't know that, I was put in a very difficult position. And I should have known about all the misconduct going on at the Office of Alcohol Testing. And because I didn't know that, I was put in a difficult position and I was unable to give the appropriate advice. Well, what else? These breath tests, the manner in which these breath tests were being produced was scientifically unreliable. I didn't know that. I didn't know that the protocols, that they didn't have protocol, and it was a scientific underpinning. The protocols, I'm no scientist, but I've gone to enough courses to recognize that it is a building block of any scientific lab. You've got to have protocols. And for the Office of Alcohol Testing to stand there and say, well, we didn't have any, we were calibrating these machines without protocols, scientists across the country's mouths dropped. You just didn't do it. But unfortunately, the fox was guarding the hen house. Nobody was holding them accountable. And now we do have an accrediting body. And the good news is they are accredited. So keep in mind, there's a due process claim, and Scott talks all about the due process claim. And what is that? That obviously is the intentional misconduct of intentionally. Now that's the language in the agreement, the language in the court's order, the language that you can find all over the EOPS investigation, intentional withholding of exculpatory evidence. I just don't know how more powerful you can get, right? The very agent of the government intentionally withholding exculpatory evidence. That's the language that you have to work with. There you have it. And again, recognize that you do have a contract claim. They've promised not to use it. These are the cases. Again, there are a whole variety of different cases, but these are some of the cases that I would say are kind of the foundational underpinnings. Obviously, Scott, obviously, Ferrara. These other cases I've kind of highlighted here, Grace and Pike. Those are jury trials, and the analysis just a little bit different, right, between a plea and a trial. I had a case out on the Cape and the Islands, and it was It was funny because, and you got to look, by the way, at the dockets. But the fact of the matter is, it was clear, not guilty. The docket said not guilty on the OUI impairment, but guilty on the breath test, and it divided. So that was a pretty easy argument to make. So that's one of the things I would highly recommend that you look at. Please realize, everybody, I'm going to ask everybody, do not. I've gotten a variety of calls, and I did a lot of training with the Committee for Public Counsel Services. This is not an ineffective assistance of counsel claim. It is not. And well, I think what has happened here is that after the 27,000 letters were sent, some counsel who are representing individuals sends out these letters to lawyers back in 2013 and 14, and hey, I've got this case, and I've read some of the letters, and it's kind of disturbing and jarring when you get a letter from another lawyer saying, hey, I got a motion for new trial, and I've read some of them from the lawyers, and it's not ineffective. And what we want is trial counsel to be put on notice, because trial counsel might be able to help, but nobody knew about this. And I just want, we're all in this together, and we want to make sure that we work together. We don't have to be, throwing letters around in an adversarial process. It is newly discovered. We didn't know about it. And the due process claim, we talked a little bit about that. So these are the cases, the standards I have. You can have these slides, but this is really, really important that you understand the grounds of what you're going forward. Again, the question, very, very basic question that you're going to have to answer when you draft these memos, and be thorough with the memos. Is it new? Well, of course it's new, but you're going to have to talk and flesh that out a little bit, and be the teacher, be the educator in these memos when you talk about it. And obviously it's important, but we didn't know that the breath test results back in 2011, 12, 13, 14, 15, and beyond were unreliable. We as lawyers went forward with these pleas and these trials, and we didn't know that they were unreliable. Well, we do now, hence it's new. So again, these cases talk about that, and they give you, and you've just got to sometimes, and there are a lot better lawyers out there than I in the written product, but you have got to sometimes spoon feed and put that information out there, because if your particular case is the one that is going to be challenged at the appeals court or the SJC, you've got to lay it out. You can't just assume. And I've seen some of these motions and they're just slopped together. Spend some time. Yes, it's unknown to the defendant. We didn't know anything about it. We didn't know how dysfunctional the Office of Alcohol Testing or how unreliable this was. And obviously with breath test, the question is, how important is the piece of evidence? Is it, evidence that we didn't know about is completely collateral, or does it go at the heart of the matter? Come on, it's a breath test. It's a drunk driving case. Yes, it is important. And we'll talk a little bit about, is it only important with per se? No, it's not only important to per se. Check your jury instructions. Read Colterri. There's a bleed over impact even in the impairment. So keep in mind, there is not a more important piece of evidence than breath test. And so you're going to be arguing this, and that totality of the circumstances is what your judge is going to look at. It is probably the most important 3 words, at least with regards to this kind of motion. The judges obviously have had their training, and I can tell you just by my speaking to them, and this is going to be their throwdown. I would suggest to you that if your motion is going to be denied, it's going to be denied on a factual totality. So make your argument strong. Ask the right questions. Put together a motion to vacate that has teeth, and not a couple pieces of paper, throwing it to the clerk and hoping for the best. Again, the 2 big grounds will be your due process claim or your newly discovered evidence claim. They definitely have a great deal of bleed over arguments, but those will essentially be the two grounds in which you're going to be arguing to a judge. Scott lays it out beautifully. I keep saying Scott because I found the read in Scott a heck of a lot easier than I did in Farrar, the Supreme Court case. So take a look at that case. It breaks it down beautifully, and it explains why the non-disclosure of newly discovered evidence is an enormous due process violation. And again, I go through, here with some, I try with some specificity to talk to you about the how prejudicial and material the breath testing is. It's really something that I think you're going to be able, to argue without a great deal of problems. It's a breath test case and it's a drunk driving. So these are the cases that are involved. And again, I'm overemphasizing this, but let's think, is it new, right? It's a question that, well, what's new? What's new? Well, breath testing, right? What is in the agreement, what is in the order is that there's a promise that the DA should not have used breath tests. You'll see it at trial. Trial means trial or plea, right? It's right there in the agreement. It's signed by the DA. It's part incorporated in this order. And that's new. We didn't know that. We didn't know that they weren't going to, they promised not to use it. We didn't know that the breath tests were unreliable because of the lack of protocols. We didn't know that the breath test should not have been used pursuant to the order. So remember that, right? We have the agreement, the contract, and now we have an order. We didn't know that the OAT was completely dysfunctional, ignoring very basic tenets of science. We didn't know that they were withholding and hiding worksheets. So again, I say to you, don't let the don't let the prosecutor or a judge distract you. These are just some very basic answers that you're going to be able to talk a little bit about. And again, this is where the judges, the prosecutors, this is kind of the heart of the matter. You're going to have to really dig into this to determine on these pleas, right? What influence did it have? And is the totality of the whole circumstances so overwhelming? Is there the level of intoxication and the evidence above and beyond your breath test so potent that you're not going to be able to overcome this hurdle? This is what you've got to think a little bit about when you prepare these motions. There's affidavits about potential defenses that I would suggest that you add, medical defenses and the like. And again, this is all about whether or not, right, the due process of a knowing and an intelligent waiver at the time of the colloquy. And again, you'll see in Farrar, there's wonderful language in there. When you're talking about a plea, keep in mind that did it influence, could it have influenced the decision-making process? Could it have influenced trial counsel's advice? Of course. But there will be nuances and there will be issues. So one of the things I want to emphasize here is, again, this is not a strictly Concord District Court case. This has statewide implications, and this is, again, the Supreme Judicial Court, the Justice Carey and Dolly all have made this particular case the statewide guidance on breath testing. And I've compared the two languages in Dukin that is very similar in our case, where Brennan held that the prejudice caused by the Office of Alcohol Testing misconduct against the consolidated defendants and the resulting, damage to the criminal justice system, OAT must first demonstrate, and he goes on. But this was an absolute colossal disaster for all of us, for all taxpayers. So again, another kind of piece, another element that the cases talk about is you need to have a government action. And look at the Dukin, the Scott case, all talk about this. There's wonderful language in there. Don't let anybody give you pushback that this is some sort of third party that's not a government actor. Of course it is, and you'll see the language there, and I presented this to you. Office of Alcohol Testing is a statewide calibration lab for all DAs from the Berkshires to Boston. Again, I talk about this. Don't be confused, and don't let anyone say, well, we only were going forward on the impairment. There are a lot of cases that you're going to be able to argue successfully, and the model jury instructions talk about this. If a breath test was used in the decision-making aspect, recognize it can be also used in an impairment theory, right? Colterri tells us that. And if that breath test was used at a plea or at a trial, there is great transcension from the per se theory and the impairment theory. And you will get some prosecutors who will talk a little bit about trying to kind of dissect the two. Don't let them do it. Take a look at your jury instructions, take a look at Colterri, and you'll be able to formulate, I think, some very, very compelling arguments. The Birchfield versus North Dakota case has some very nice language. I quote it here. Breath tests have been in common use for many years, and their results are widely credited by juries. Again, important stuff, right? A breath tests are the cornerstone, and they're not just for your per se. So take a look at these cases. If you have one of those cases that you're going to be arguing and you're scratching your head like, what? Look at Birchfield, look at Colterri. That gives you some great language in there, how a breath test can be utilized in a trial and the decision-making process, not only with per se, but with impairment. So these are, again, I talk a little bit about the two theories. It's important. You will have, I've heard it, you will have prosecutors trying to dissect the situation. There are some cases here in Western Mass that as Ananias marched on, some of the judges actually, in the midst of their colloquy, put it right out that you are making this, you're actually making this decision and waiving your right. You're making this decision exclusively on the impairment theory. So one of the things you are going to have to get, everybody, is the transcript and listen to the judge's colloquy. We're kind of like running out of time, and I apologize for racing, but you can see here, I cite Colterri. I talk about, a motion for new trials and why, what kind of a case are you looking for with a motion for a new trial? What should you be doing? Recognize, everybody, please recognize, not all cases that fall within the time parameters are good cases to bring for motions for a new trial. There are some potential negative repercussions that you can bring upon your client. You don't just look at a case and say, hey, it falls within the timeline. There was a breath test. Let's go. You got to know more. You got to review the history. You got to find out whether or not your client maybe benefited from a huge benefit of a bargain deal. I don't know. You've got to also realize that this is unlike the Dukin, Farrak, and the Bridgman decision. All right. Because there is a possibility. I'm not saying it's going to happen. There are cases that you can use for your protection, but there is a possibility that you could be exposing your client to greater penalties. Bridgman does not control the day on this particular issue with our cases. And there's a variety of different reasons why, but you've got to analyze whether or not it's a healthy decision to bring forward. Hey, I pled out on a fourth offense and I didn't go to jail. And here's the reasons. Maybe, I'm not saying, maybe that is not a good motion to vacate. You win the motion to vacate and you put your client, in a more difficult position. What are some of the cases? I mean, I've had a lot of fifth, fourth offense refusal cases, right? That I'm able to reach back, remove one of these breath tests or two of these breath test cases and restore people's right to operate. Keep in mind that you really have to do an awful good job at convincing, judges and the prosecutor that this person is safe. And we'll talk a little bit about that. So this is a case upon reconviction that you're going to have to know. There's two different rules here. There's the federal rule and there's the Massachusetts rule. You have a lot of great language, and this Pierce case is kind of the beginning, but you have a lot of great language to protect yourself from a greater penalty. So let's say you win your motion to vacate, and now the prosecutor looks at you and says, okay, we're going to retry it. And your client could be exposed, is the third offense, and now they want to put him in jail and they didn't go to jail before. Whoa, you've got to look at this case, and you got to look at the progeny and Massachusetts cases, because it's important. There is a presumption of vindictiveness, and you gotta keep all of that in mind when you're analyzing the situation as to whether or not it's a healthy decision for your client. So you've got some of these cases too. I just, unfortunately, we're running out of time, and I've just got to, I know there's questions, and I'll try to stay a little bit longer afterwards, but you've got multiple charges, right? Look at this decision goes to the OUI. This decision goes only to the OUI. We as practitioners in this area know that many times there's a negligent operation, or there's other cases that were part of the charge, and the fact of the matter is, our motion to vacate exclusively goes to that. What happens to those others as part of that kind of global disposition, you really need to analyze, and you have to make that part of your decision-making process. I'm not going to talk about that, by the way. Any of you have 7110 machines, call me. I've been somewhat successful, but there's a whole different analysis to that. Okay, practical implications. You know that the 27,000 notices went out, and there was a question earlier. Did every single defendant receive notices, or could there be defendants out there who did not receive notices? And the answer is yes. We did our best. The Commonwealth actually hired a third party, and we did our best to identify all defendants dating back from 2011 who had a breath test case. What we also did is we made part of the agreement is that we involved the Board of Bar Overseers, and we were able to obtain all the lawyers who represented those defendants. So we sent out two groups, emails on one on the lawyers, and we sent out hard copy letters to the 27,000. And that was part of the agreement and the order. We drafted the notice. It was then presented to Judge Brennan. He approved it. That the notice that Justice Paula Carey signed was the one that we presented, and then her office made some changes to it. There's the notice. I mean, any of you have done this, you recognize that that's the particular notice. I can't believe it's only 3 paragraphs, and that took months. All right, so when you get one of these cases, these are some of the kind of the basics that I would highly recommend that you do. Request the transcript. I was just on the phone emailing back and forth with the prosecutor, said, well, we didn't use it at the plea. We didn't use that at the plea. Yeah, listen to the transcript on the colloquy. Yes, you did. So it's important, a lot of these changes of plea and colloquies are all recorded, right? So you're going to have to take a look and listen, make the request. And obviously you want to obtain a copy of the police report and the docket, right? And with regards to that, breath test, breath test, breath test. Look how the breath test was used. Find out, obviously, you've got to bring the motion to vacate before the judge who either took the plea or was your trial judge. Some might have retired, some have moved, and that goes to the first justice, and the first justice, she will make the decision as to who is going to hear the case. There'll be a particular protocol involved in your district court as to who's going to be handling the case, but you need to find out who is the judge and is that judge still available. I always suggest to speak to original trial counsel who handled the trial or the plea. And I say that it really is disturbing when these letters go out, but speak to the lawyers. I've got an affidavit at the end of the slide. It's a very generic affidavit, but it essentially says that the breath test was part of my decision-making process. I didn't know about all these problems. If I did, I might have given different advice. I always ask if there's any medical disorders that could have been used. I put that in my motions to vacate, just to give a little bit of teeth to the fact that, hey, without the breath test, I had a defense. And it really does give an explanation to why there is a defense. I also incorporate recovery. If it's part of the client's story, I'm a big believer in that decisions with juries, with judges, with prosecutors, many times aren't made on logic, but it's made with the heart and the gut. And if you can make your prosecutor, your judge, or feel safe, and how about the registry of motor vehicles? What's the first question out of their mouth, right? What's your date of sobriety? So I encourage all my clients as we do this to involve themselves in some sort of recovery program, and I include that, as part of my negotiation and presentation. I think it's very important. These are just some of the things that I do, and some of the things I ask my clients to do. It's completely their decision. I'm not some recovery coach. I'm their lawyer, but tactically speaking, it's really helpful. So what are some of the things? Keep in mind, I'm going through this really quick, but let's just say you have a case, and it involves, I had the communication with the registry of motor vehicles. Any of us who practice administrative law before the registry of motor vehicles realizes that it's a very arbitrary, difficult place. So let's say you have a second offense refusal. She comes into the office, and the first is an Ananias potential motion to vacate. And so you've got 3 years, right? 3 years is bye-bye. They can't drive. She's got 2 kids. She's a single mom, and she needs to get back on the road. So you bring a successful motion to vacate case number 1 that was 3 years ago, but the registry of motor vehicles has still suspended the license for 3 years. Now what? You won in court, but how does the court now communicate with the registry, and how do you get that person back on the road? So I hope I have forged a little a blueprint here to help with that. I've actually worked with trial court, and Zach Hillman has been really helpful with this. And there are new programs in your district court computers now that are going to be able to do this with new codes. So there's new codes based upon our Ananias litigation. But I put this statute up because this is what the registry did. They played the gotcha game with me. I had these motions, I brought them, and I remember I was before the Registry Appeals Board, and the Registry Appeals Board said to me, Mr. Bernard, I see what you've done here. Why don't you just show the registry your motion? it's certification that the motion has been allowed and it no longer is a second or third or fourth offense. And I remember looking up at the board and I said, I've done that not once, but 3 times. And I said, I have them here. And I presented them to Chief Registry Counsel at the time. And they were able to put my client back on the road. But with that, this is their argument. We can look at all the certified copies in the world, but the way the registry will receive communication from the courts is upon the disposition of such matters, the clerk magistrate shall forthwith send an abstract. That's not an abstract, is it? Now the computer has a code and there is an abstract. Then back in the day, right, abstracts were hard copies. No longer. It's all electronic now, but there is an electronic abstract. So if you are in one of these situations, everybody, file a motion for a corrected abstract. I do this in my case. You've got to ask the judge, request the judge to order the clerk to make because what they have to do is they have to correct the old plea. And that's what and they're not going to do that unless the judge orders them to. So this is kind of another step from a practical standpoint that I would be recommending to you, that if you're looking, the reason why you're filing this motion is to get your client back on the road. Make sure you realize that excused upon the road to do that is filled with pitfalls, and you've got to make sure that you appropriately communicate with the clerk's office. They're going to want this order. They're going to be really reluctant to go in and change that abstract unless the judge orders them to do so. This is the abstract, right? That's the old abstract that is still in some of these cases. Some of these cases still have this old abstract, and you can see here in the right hand where it says comment. And what they're doing now is motion to vacate allowed or something to that effect. But with that and with this new code and your order, you should be able to get your client back on the road. I've been successful now. One case took months, but now, I think all the district courts have gotten Jack Hillman's code changes. And so that, if you have any questions, you can speak to me. That's a suggestion for your prior counsel's affidavit. It's at the end. Again, it's brief, but please, reach out to prior counsel, have a conversation, and make sure that you appropriately communicate in a way that's not adversarial. It's a way that's going to be helpful, and you can work together. That usually is my last slide. And I want to say again, my good friend, Tom Workman, he's passed away now, but without his help, quite frankly, we would not have been able to uncover where we are today, uncover these failed worksheets and so forth. So my dear friend, I thank him immensely. I think about him a great deal. So I know I ran up against the clock here. I know there's questions. Let me kind of go in and let's see if I can answer these. Okay, so somebody's asking about the 7110, and I can definitely tell you, I can't do it right now. There is a bit that I would need to get into. I've been successful, but you're going to, the big problem, of course, is Camlin, right? The Camlin, Dalbert made some pretty sweeping decisions. I think there's an end run that we can talk a little bit about, but you're going to need an expert, and I use Janine Aravisu on some of these cases. Whoever asked the question, I'd be happy if you want to talk to me a little bit. All right. With regards to motions for speedy trial, yeah, that what I've been doing, I don't know about anyone else, but since COVID, as we all recognize that notice becomes very important, when you're arguing speedy trials, I would recommend that when you get one of these cases in, you can just put the Commonwealth on notice. And that's what I think your speedy trial cases talk about, the notice aspect. It definitely puts you as the litigator in a very different position. But the sooner you put them on notice that it is an issue, I think the better. I'm looking here at a particular police department breath test recently on a video. Nearly became a refusal when the client blew again, rejected attempts. Okay, third attempt. Keep in mind, everybody, that the 9510, Tom was just on the, has a 15 to 20% increase for whatever reason in what I call attempted failures. It's for whatever reason, the 9510 versus the 7110, you get many more attempted failures on the 9510, and I can't. Oh, there it is. Tom Workman was looking into this. Yes, whoever wrote that, yes, he was. He was hot on the trail, and he was in the midst. He was, on the midst of writing a paper on it, and unfortunately, he got sick. But it's a very important issue. I can't answer it, but it's real. It is very, very real. I can't tell you why, but I can tell you, if you speak to Joe Anderson, Dr. Joe Anderson, they have 9510s out in the state of Washington. He was so helpful. He testified in Ananias, and he testifies in some of our cases here. But he is somebody, whoever asked this question, who could definitely be of assistance regarding that. There's another question that says, if a motion for new trial is allowed on a third offense, the defendant has served the loss of life. Aha! Great question. Great question. And the answer is the registry's position on this is going to be, I think, operative word is think, is going to be, we have the right to resuspend. Everybody, that's a great question. Everybody needs to realize I'm in the midst of working with the Committee for Public Counsel Services with a declaratory judgment in the Superior Court, trying to get an answer and trying to force the registry to take a different position. But everyone needs to know, and I'm so glad that was asked, that I believe the registry's position is going to be, yeah, they're gonna double zap your client, and their position is going to be, well, it's not a penalty, it's not a sentence, and they're going to fall back on the commonly used, it's a privilege, not a right. There's another question. It says, oh, okay, I've talked too long. So anyway, if you do have other questions and you want to give me a call or throw me an email, I'm here. We're here late sometimes, but we'd be glad to help. It really has been a pleasure. You guys do such great work. I hope I've helped a little bit, and I look forward to speaking to anybody through emails or through the telephone. My number is on the presentation. So with that, I just want to say thank you. And it's 4:16, and I know I rushed at the end, but if you have questions, call me. All right. Thank you, everybody, very, very much.
Thank you, Joe. That was incredible. That was wonderful.